outside of the place. That's where they
Dustin Jones, Bruce. And this is going to be, who's going to be helping from the state on this one? On
Mike is.
Mike is. Mike is. Who's Mike is?
I don't know Mike is.
Mike is.
I guess
there
Mike is. Today I'll play part of Mike is.
Hello, Dustin Jones. Please, thank you. Came in from San Antonio yesterday, a rainstorm. Driving Interstate 10, that's under construction in a rainstorm, with everybody doing 90 miles an hour, is an experience. Nose to tail, an experience. Saw my wide flash.
That's pretty difficult.
Man, but you know, the whole Interstate 10 is big. I mean, there's so much construction and everywhere. Does anybody ever see anybody working on those construction sites? Has anybody ever witnessed that? Have anybody seen that?
A few.
All right. It was Sunday. They're not going to be listening. Okay. We call 24CR1326, the state of Texas versus Dustin Keith Jones Jr. That's you. And you were here with Mr. Smith, your attorney, and the state's attorney. Earlier, you pleaded guilty to the first-degree felony of aggravated robbery as indicted in this case. A pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it?
Not from the state.
And defense.
No, yeah.
Then it will be made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 8 years imprisonment. So we are looking at no less than 5, no more than 8 years confinement in prison. Regular probation is not an option in this case.
Whoa, pause for a second. Did you catch that? The judge just drew the battle lines. No probation, no easy way out, only 5 to 8 years in prison. This is where courtrooms get cold real fast. One wrong move from the defense, and Dustin's life takes a hard left turn straight into a prison cell. What would you gamble if your entire future hung in the balance?
But deferred or unadjudicated probation is 10 years anyway. All right. State, did you want to go first? Or
Judge, I'll
you can
defer.
go first? And you can pass and end. Go ahead, Mr. Smith. You're the guest of honor as well as.
When Sonny was handling this case, the last thing that we talked about is that he told me that out of the facts of this case, of what happened, that he would not oppose. He wasn't in a position to recommend deferred probation, but he would not oppose the court granting probation if that's what the court felt was appropriate. This young man.
Let me ask you this. Is he opposed to 8 years in prison?
You're not opposed to that either. That's to my knowledge.
Well, those are two big differences.
Right.
Okay.
The reason for that attitude, Judge, is because under the facts of this case, Mr. Jones is 19 and
how old were you at the time of this event?
At the time of the offense, yes, sir.
Okay.
And, he doesn't have any non-violent offenses in his past, and he does have.
So there's an aggravated robbery pending in Harris County, though, right?
Yes, Your Honor, and I wanted to address that.
Yeah, I'd like to. Yeah.
All I can tell the court
19
is that the
family is being month after this.
And boom, plot twist. Out of nowhere, the defense casually drops that Dustin has another aggravated robbery charge pending in Harris County. That's like telling the court you brought a second ticking time bomb to the party. The big question now, is Dustin just unlucky, or is he a repeat player in the criminal game? Either way, this revelation just torpedoed any first-time mistake sympathy.
Sir?
That was the month after this.
Yes. But what I can get, and I told Mike this morning that if he needed to verify with over there, the family is being told if this guy, young man's been raised by his grandmother, and I've talked to his grandmother many times. She's talked to the defense attorney over there. The defense attorney is telling the family that he was only implicated on those charges, and that it is her understanding that the case isn't going to be dismissed. I have not verified that. I have not talked to the DA's office.
Has it been indicted?
Yes. Oh, yeah. So just about any, the way they handle it with their Harris County, I mean, they don't, years jail, person boom, they get it indicted out pretty quickly so they can get it to the district court level. I told Mike this morning that if he needed to verify that this morning, I totally understand. Because
I don't have any.
I know the court would like to know what's going on.
But I didn't know if it was disposed or not. If it was disposed, of course,
It hasn't been disposed of yet.
by a plea or otherwise, then the court can put it into the equation.
When I
But
looked
if
it
it's
up,
pending,
I looked it up this morning. There was
all we have is a probable cause indictment.
an active case because he failed to show up for court over there. So
Yeah, that's because I think he was here, in jail, but I could be wrong about that.
So on this one, go ahead. We'll just focus on this.
Okay.
I'm not going to consider whatever might have happened.
What happened in this case was, as shown by the PSI, the defendant was going to go visit his cousin, who is the victim of this case. He and his cousin are close. They know each other very well. They see each other a lot. And so the defendant goes over there, but three other guys also go over there with the defendant. And he just thought they were going to go over there because they were going to play, dice and stuff like that. My client had no idea that what those guys did was going to happen. And what happened was that they while there, the victim went to his car, and the guys pulled out, these other guys pulled out a gun. In the reports, it clearly shows that the victim said that these other guys pulled out the guns, but Dustin didn't have a gun, and at no time did he point a gun. And these other guys were threatening the victim at no time, and the victim says at no time did Dustin say anything to threaten the gun. Dustin is in a state of panic. He has, the court might look at his history. He has in his past history, he has had some mental issues, which the family is stating has been resolved, but it did require medication. And while he was much younger, he suffered from dyslexia, and also he was having some mental health issues. But he's always been provided by his grandmother, a structured environment. But when all this thing all of a sudden happened, these guys took off runs. My client, he didn't know what the heck to do. He took off running too. And so, all the appearances were that he was there during an active robbery, and in fact, he was there. But Sonny and I discussed it for a long time. We decided that the best approach, of course, is to enter a plea, under, a theory of a party. And so the Dustin is, and we provided the court a very detailed supplement PSI, which has his awards while he was younger, most improved student, reading programs, math achievement awards, certificate of participation, science awards, things of that nature. And he also got a license for the barber, and we also included character letters, and these character letters are very impressive. They come from people who all say that he's very, very active, a member of the youth ministry there at the church, and was well liked, and he was well trusted. People who have been in education for over 40 years and told the court in their letters that he has been active in the youth ministry, and that they're very, very supportive of him. There was one letter from the barber instructor for Jay's Technical Institute, and says that he is a great young man and he would be reinstated in the school upon his release. And so he has a future. The supporting documentation just kind of gives some personal information and insight, like Little League programs and things of this nature. So our opinion is that while technically under the law, he was there and he took off, and gives all the appearances that he participated in this robbery. This is a young man who has a very, very, very supportive family. We feel that he could successfully serve probation, deferred probation, under any kind of terms and conditions that the court deems necessary. And so we're asking the court to take all of that into consideration and allow him. Plus, I talked to my client about the fact that in the event that the court sees fit to place him on probation and any of these other guys come to trial and he is subpoenaed, he understands that he has to tell the truth, and he'll get on the stand and testify to the truth of all of this. But what his version is meets the same version of what the victim says, and so they cooperate with one another. And so we're asking the court under these unusual circumstances to grant my client deferred probation.
What did he do wrong?
Well,
he's pleaded guilty.
He's pleaded guilty under my advice, because...
Well, it's not your plea, it's his plea.
Yeah.
He signed a document under oath, and he admitted to me that he committed this crime. So what is it he did wrong? Because all I'm hearing is an exculpatory argument.
This is brutal. The judge is slicing through the defense's emotional smokescreen like a buzzsaw. Notice how he keeps hammering one question: what exactly did Dustin do wrong? And the answers keep circling the drain. This is courtroom chess at its finest. The defense is trying to paint Dustin as an innocent bystander, while the judge demands cold, concrete culpability. Who do you think is winning this verbal tug of war?
What he did wrong is that, under the law of parties, there was some type of assistance of taking the people there. And the evidence from the state is going to show that he aided or attempted to aid. And then when those guys took off running, he took off running as well.
Presence alone at the scene of a crime is not guilt.
I totally
What is it he did that's wrong?
I totally agree. But
y'all are dancing around it. What did he do wrong?
What we feel that he did wrong is covered by the law.
What? Or covered by it? I mean, I don't read that in the law of parties. It doesn't talk.
Law of parties says that if anybody
Mr. Jones.
attempts to aid.
What did he do?
He was there. He was present with the people who pulled out their guns. And when they took off running, he did too.
He invited the poor victim to the group, right? They smoked marijuana for a while together. Then the victim goes to the car. Then the defendant and others brandished 2 rifles and 2 handguns, demanding that he remove his clothes, which he refused. They pointed firearms at him, searched his pocket, stole $800 in cash and a Cash App card, then threatened to kill him before fleeing. Is that about one?
Talking about those other three guys, yeah.
He fled.
He
invited the victim over. He smokes marijuana with the victim.
They met there to the victim.
He smokes. He's using drugs with the victim. The victim goes to the car. He and the others go to the car with him. The others point guns at the victim, take his clothes, take his money, and then run off. He ran.
He didn't point his gun.
He ran.
Yeah, he ran. But he didn't have a gun. He didn't point his gun to the victim.
Do you see anything wrong with this for him? Under the book of Proverbs, guilty men flee when no man pursueth, but the righteous stand bold as a lion. You fled. It's amazing what the book of Proverbs has that enters into this courtroom all the time. Why would you flee if you were not guilty of anything? Your own cousin.
Nah, I ran because the dude swung a gun at me and I didn't know what to do, so I took off.
Oh, you were under duress. They pointed a gun at you, so you were under duress. Keep digging the hole. Are you guilty of this crime or not? Or you pled guilty under oath. Did you commit perjury when you swore you were guilty? Took the oath and swore you were guilty. And then here today, hedge. Are you guilty or not?
Yes, no.
Sir?
I'm guilty.
Is that your final answer then? No. You've thought about it a long time, is it? Or are you guilty of the crime?
I'm really not guilty though, not because I didn't do it.
Move to withdraw the plea, Judge.
Okay, the plea's been withdrawn. It's set for trial. There is no deal. We'll let a jury decide your fate. Okay, that is all.